tuned in to the Andrew Lawton Show.
I'm going to bring into the discussion in just a moment's time Keith Wilson, who is a lawyer extraordinaire, a King's Counsel, the first King's Counsel I've ever met, because he was the first to change from the QC that he had for so many years. Keith, it's good to talk to you. Thanks for coming on today.
Thanks for having me on, Andrew.
So let me start first off with this business with Doug Ford here. Why on earth is it that the premier would have to be summoned to appear when just last week he was saying, yeah, I'm all for appearing. I'm all for coming. They just haven't asked yet.
Well, he's given the answer with the judicial review you mentioned that he doesn't want to testify. And that, of course, raises some interesting questions. What is he worried that he's going to be asked? What is he worried that he might have to answer? This is very surprising, even to me, who, as you can imagine, with all the things I've been through, I've got a pretty high threshold for surprise, and this one trips it handily.
Yeah, I mean, I would say that as far as people that we could benefit from hearing from here, the Ontario government would be a fascinating one, because this was the government that had to grapple with the Ambassador Bridge blockade, and it's the government that managed to clear up that blockade without the Emergencies Act, using regular policing powers just in a matter of about 48 hours. So I actually think hearing from Premier Ford about why you couldn't just apply what you did there to Ottawa would be a fascinating revelation for the commission.
Well, and for all of us, I mean, what's striking is compare it to something else, the Premier Ford's position, as we now have learned in the last number of hours, which is compare it to the position of the Prime Minister. Doug Ford was not a decision maker with respect to the invocation of the Emergencies Act. The Prime Minister was, and he's expressed a willingness to testify, is not requiring to be subpoenaed. He's coming under his own volition. I think he realized he had no choice. But, you know, why Premier Ford would do this to himself? He's likely to lose his judicial review just because the case law is so clear. He's not precluded from invoking a privilege when he's asked a question, if the question triggers privilege. So this is bad political strategy, in my view. He would have been better off to just say, yeah, I'm happy to come and share whatever information I have and help Canadians get to the bottom of this. It's a very important inquiry and happy to be here. Instead, he's just embroiled himself in a self-imposed controversy.
When we talk about the witnesses that are slated to appear, we've got members of the Convoy's board, we've got more police representatives, we've got some bureaucrats from all number of federal departments and intelligence agencies, we've got federal cabinet ministers. I know that this is fluid and more witnesses could be added here. We also have that statutory cutoff where the report has to be tabled by February. And I'm wondering, is it possible to cast too wide a net here and bring in more people than are needed for the commissioner to make the decision? Or is your view that this witness list is actually so light that key details are being missed?
Well, you're right that it's a dynamic process. The witness list that everyone's seen was the first preliminary witness list. There will be a new witness list coming out soon, and it will have a lot more names on it. And that's the nature of this process. We've been working with the Commission's lawyers on expanding the number of witnesses that will speak on behalf of the Freedom Convoy protesters. So it is, and the other thing that's happening here is, which is really unusual for lawyers anyway, is that normally before you go into something like this, all the documents are disclosed and you have a chance to review them. We're getting new documents disclosed every day. And the last count we had, we were over 15,000 records, over 20,000, well over 20,000 pages of documents. So the paper evidence just keeps coming in by the day. That, depending on our review of it and what we find and other parties finds, then triggers a request. So, for example, one of the things that our group and a number of other lawyers representing other groups made a formal application late last week, to have the commissioner issue a subpoena to the head of the CBC to testify, because one of the focuses in the Order in Council for this public inquiry is to examine misinformation and disinformation And given that, we couldn't understand why the head of the CBC wasn't at the top of the witness list. So we know that Mendocino and other ministers have routinely referred to fake news stories as a basis of their decision making. So this inquiry has been fascinating since the first day. As you note, we're on day 8 of 38 days of evidence. We still have at least 30 days to go, assuming we don't start sitting Saturdays. And I think we're going to start sitting the hearing on Saturdays very soon.
Just on a this is not a question that's coming from anywhere but my own mind here. Is there a mechanism at all to delay the production of the report if for some reason they need more time for hearings, they need more witnesses, more time to put it all together, or is that a complete no-go under the statute?
Well, the statute's simple. It says that you have to table your report before the legislatures of the provinces and the Parliament of Canada and the Senate within 365 days of the revocation of the invocation. Okay. So that puts us into February next year. As to whether or not the commissioner decides, so he's got 2 blocks of time left, hearing time and then review and writing time. He may decide to chop a week or 2 off of his writing time for him and his commission staff and extend the hearing. The only other, I've been asked this question many times, the only other situation would be if the Parliament and the Senate decide to amend the Emergencies Act to modify Section 63 and change it from 365 days to some other number. So we can all guess at what the mechanics of that might be. But the commissioner is running a very tight ship. We put in a request each day by 5 o'clock for the witnesses we're going to be cross-examining 3 days from now. And that's the rule we do every day. We're working 7 days a week, many, many hours a day and night. And we have to identify all of the documents that we're going to put to the witness in cross. So we would have identified Interim Chief Bell, I guess on Friday of last week. And then we may say we need an hour and a half to cross-examine Interim Chief Bell, and then the commissioner will say you get 15 minutes, or you get 10 minutes, or you get 20 minutes. So that's how it works for all the parties. And he's got a stop clock up there, as you probably noticed. He'll sometimes let you run over a little bit, but he's running a pretty tight ship. And right now we're assuming we're going to finish on time, but we're very much alive to the fact that in the next couple of weeks we'll probably be sitting on Saturdays and holding the hearing on Saturdays, as well as going till 8 and 9 o'clock each night.
I want to play a very brief clip here from today. This is Brendan Miller representing Freedom Corp during his cross-examination of Interim Chief Bell earlier today, talking about this idea of there being a plan by police without the Emergencies Act.
Last question, just because I just want to get this cleared. But so you're saying that there was existing laws that you could have done the same thing under. Is that right?
We had a plan. We were going to execute a plan.
Thank you.
Very clear question. You had existing laws. The interim chief says there was a plan. We had a plan. When these sorts of revelations came out last week, there was a part of me that wondered if, in very dramatic Hollywood-like fashion, Brendan Miller could just say, I rest my case, nothing further, and go home. Because really that seems to be inherently disqualifying for the Emergencies Act the way the act is written.
Well, when Brendan, we're thrilled to have him leading our team and being the lead barrister. That was to be my job. But after I assessed Brendan's skills and the role that I'm taking in this inquiry and the fact that I'm likely to testify, it simply wasn't proper to have me be the barrister. But Brendan's doing a terrific job. But when he did his opening statement, you'll recall, Andrew, that he was very straightforward. And he laid out, here's the 4 things that the government has to establish, that there was acts of sabotage or espionage. There will be no evidence of espionage. There will be that they have to establish that there was threats of serious violence against persons and property. There will be no evidence. And he went through the list in his opening statement. He reframed his opening statement into cross-examination questions when he interviewed the head of the OPP's intelligence unit. And he answered each one of them, in the negative. There's no evidence of serious violence against property. There was no evidence of insurrection. There was no evidence of terrorist activity. All of these requirements. So after that cross-examination last week of the head of the OPP's intelligence group, we did kind of joke, well, time to pack our bags and head home to our families. But of course, we got to see this thing out, and we will, because it's not just the legal test that's at issue here, it's the narrative. And I'm really concerned about this element of misinformation, disinformation, because in my view, having cross-examined all the various government experts and officials on the Peckford case with respect to the justifications for the mandates and the vaccine approval process and all of these other issues, I know where the disinformation is. It's from the government. And so there's other narratives that need to be explored and exposed, and it's going to continue to be a fascinating inquiry in my view.
You mentioned the Peckford case. You and I have spoken about this in the past, and I covered the hearing that took place on the federal government's application to dismiss the whole thing as moot, because in their words, the mandates were gone. You don't need to be vaccinated to get on a plane. Case closed. And it was quite disheartening the other day when the federal court justice, the associate chief justice, approved that. She granted that motion. She said this is moot. Reasons have not yet been published here. But even though the federal government in its own language has said this was a temporary suspension, they've managed to essentially convince the federal court of this country that it's not worth hearing whether that mandate was unconstitutional to begin with. Now, I know Premier Peckford, Maxime Bernier, some of the other applicants as well, I believe, have said they're going to appeal this. But I was wondering if you could explain, in the absence of decisions, why you think that went the way it did, in the absence of reasons, rather.
Well, I mean, I hate to be cynical, but I have no choice given what I've seen. And it's just clear to me, when you look at the decisions of our courts at the provincial level and the federal level, they've just been unwilling, lacking the judicial courage, I believe, to do the hard analysis. I don't feel that, there's the image of Lady Justice with the scales of justice and the blindfold. The blindfold's probably, down over her nose right now, is how I'm feeling. And they're just, when you look at the legal test for whether or not to grant a mootness motion, when there's a serious constitutional issue at play, is one of the reasons not to strike out a case for mootness. And we have clear, uncontroverted evidence that over 6 million Canadians' fundamental right of mobility under Section 6 of the Charter were grossly violated, resulting in them being unable to be at the side of dying loved ones, attend funerals, be there for their first grandchild, to help a loved one be discharged and recover from hospital, to go to weddings and other important celebrations. That this was a violation of charter rights on a scale that has never occurred in our history and is almost unimaginable, but it happened. And for the court to say, well, nothing to see here. They suspended those travel mandates. Now move along, everyone, is not helpful. The courts, as I said to the judge in my oral argument, provide a fundamental role in a modern democracy and a civil society. They're the third leg of the stool. We have the legislative branch of government, we have the executive branch of government, and we have the judicial branch of government. And they're to perform checks and balances. And what's happened with this mootness ruling is the federal court is checked out, and that doesn't make the stool more stable.
I've remarked on this on the program in the past, but when in 2019 the Leaders Debates Commission banned True North and Rebel from covering the debate, we filed a case for an injunction. We won, and our longer-term case was dismissed as moot. And then in 2021, the Leaders Debates Commission does the exact same thing with Rebel. Rebel goes and files another case, wins again. So as a matter of practicality, when there is a significant risk that something like this is going to happen again, I I think it should be heard. But as you've mentioned, even if we knew that the mandates were done forever, which I wish we could take for granted, but we can't, this was such a significant breach of Canadians' rights that it should absolutely have a declaration on record that it was unconstitutional. And I hope that appeal is successful, Keith. I do. Just going back very briefly before we let you go to the Public Order Emergency Commission, this week we're hearing a bit more from police. I just got the list of expected witnesses for tomorrow. We've got Russell Lucas from the Ottawa Police Service, Marcel Baudin from the OPP, Robert Drummond from the Ottawa Police Service. Are we expecting more of what we've been hearing, or do you think that from law enforcement there's still a little bit that could come out that might qualify as a bombshell or a smoking gun, to use the popular lingo?
There could be some bombshells in the sense of contradicting earlier testimony from some of the other police officials, but I think we're going to see more of the same. You know that I was, along with Tom Marazzo and Eva Chipiuk, we were the ones that there's been a lot of evidence about the negotiations that occurred at City Hall, and we were the ones in the room. And we were, we just about had a big success in the early days at Sussex and Rideau, which was a really tough intersection to deal with, given the nature of the people who were protesting there. And then we negotiated with the help of former Chief of Staff to Premier Ford, Dean French, the umbrella deal to actually de-escalate the entire thing just before the invocation of the Emergencies Act. And one of the things that's occurring to us sitting there as Eva and I and Tom are listening to this testimony in real time is that, you know, we know exactly now why these deals didn't ultimately be successfully implemented. It was due completely to police incompetence. Mm-hmm. Like they just lacked the basic communication competency to place the police in the right places and remove them from other places to allow the deal to be implemented. We were constantly blocked by the police, and seeing their handwritten notes from the chiefs' meetings about knowing about the deal and the instructions and their frustration with the communication not getting through. It's just remarkable in a very disturbing way, the level of incompetency of the police that's been revealed. And I think, well, I'm pretty confident you're going to see even more to come.
And this is many things, but a national emergency, it is not.
It's a national embarrassment. And that's
well
not
said,
a
Keith
reason
Wilson.
to invoke the Emergencies Act.
Keith Wilson, I know you are plugging away daily in Ottawa, and we'll be sure to have you back as long as you can spare some time outside of the hearing room. And also your colleague, Eva Chipiuk, is welcome back anytime. Thanks so much, sir. Always good to talk to you.
Thank you.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.